এবার তুলে দিন।
Every significant case has an unwritten legend, an indelible lesson. This appeal is no exception. Whatever is formal result, the message, as we will see at the end of the decision, relates to the pervasive philosophy of democratic elections, which Sir Winston Churchill vivified in matchless words. At the bottom of all tributes paid to democracy is the little man walking into a little booth with a little pencil, making a little cross on the little bit of paper. No amount of rhetoric or voluminous discussion can possibly diminish the overwhelming importance of the point. Now, this clarifies without any hesitation that a democracy means the freedom of a little man to march to the booth and cast his opinion, express his opinion through casting vote. And if this situation is not there, would it be said that the election is being done properly? No. And then kindly count paragraph 3. Oh, it may be that, sorry, but if we may add, the little large Indian shall not be hijacked from the course of free and fair elections by mob muscles methods or subtle perversion of discretion by men dressed in little brief authority. For, quote, be you ever high, so high the law is above you. The Constitutional Court took this in the year 1978, that this sort of thing should not be allowed. It cannot be permitted in a democracy. I repeat, it may add, the little large Indian shall not be hijacked from the courts of free and fair elections by mob muscle methods or subtle perversion of discretion by men dressed in little brief authority. The moral may be stated with the telling transcends in the words of the William Pitt. I would not trouble my lord with that. Then I take your lordship to the important paragraph. What are the role of the Election Commission?
114.
No. Kindly come to paragraph 27. Thus, for everything is clear. No litigative enterprise in the High Court or other court should be allowed to hold up the ongoing electoral process, because the parliamentary representative for the constituency should be chosen promptly. Now, this is in this background, this judgment delivers. Parliament cannot be allowed to wait. They will be chosen promptly. Article 329 therefore covers electoral matters, quote unquote electoral matters. One interesting argument urged without success in Punwaswamy elicited a reasoning from the court which has some bearing on the question in the present appeal. That argument was that if nomination was a part of election, a dispute as to the validity of the nomination was a dispute relating to election, and it could be called in question only after the whole election was over before the election tribunal. This meant that a returning officer could have no jurisdiction to decide the validity of a nomination, although Section 36 of the Act conferred on him that jurisdiction. The learned judge dismissed this argument as without merit. Despite the great dialectical ingenuity in the submission, in this connection, the learned judge observed, under Section 36 of the Representation of the People Act, 1951, it is the duty of the returning officer to scrutinize the nomination papers to ensure that they comply with the requirements of the Act and decide all objections which may be made to any nomination. It is clear that unless this duty is discharged properly, kindly underline these words, unless this duty is discharged properly, any number of candidates may stand for election without complying with the provisions of the Act, and a great deal of confusion may ensue. In discharging the statutory duty imposed on him, the returning officer does not call in question any election. Scrutiny of nomination papers only a stage, though an important stage in the election process. It is one of the essential duties to be performed before the election can be completed, and anything done towards the completion of the election proceeding can by no stretch of reasoning be described as questioning the election. Now, I would say, my lord, that when the learned court found that the nominations were prevented from filing within the time, and though there is a power under section 46(2) to extend it, why should it not be accepted? This acceptance is valid, and this in no way not interferes with the election process. That's the judgment. And this, my lord, the court goes on to say, then again, my lord, kindly come to paragraph 30. The plenary bar of Article 329B rests on two principles: the peremptory urgency of prompt engineering of the whole election process without intermediate interruptions by of legal proceedings challenging the steps and stages in between the commencement and the conclusion; the provision of a special jurisdiction which can be invoked by an aggrieved party at the end of the election excludes other form, the right and remedy being creatures of statutes and controlled by the Constitution. Durgashakar Mehta has affirmed that the position and supplemented it by holding that once the election tribunal has decided, the prohibition is extinguished and the Supreme Court's overall power to interfere under 136 springs into action. In Hari Vishnu, this court upheld the rule in Punwasami excluding a proceeding including one under Article 26 during the ongoing process of election, understood in the comprehensive sense of notification down to declaration. Beyond the declaration comes the election petition, but beyond the decision of the tribunal, the ban of Article 229B does not bind. If election bears the larger connotation, if calling in question possesses semantic sweep in plain English, if policy and principle are tools of interpretation of statutes, language permitting the conclusion is irresistible, even though the argument contra may have emotional impact and ingenious appeal, that the catch-all's jurisdiction under Article 226 cannot consider the correctness, legality or otherwise of the direction for cancellation integrated with repoll. For the prima facie purpose of such a repoll was to restore, this is on the question of repoll, I am not troubling my lot with that. Then kindly come to paragraph 33. Our conclusion is not a matter of textual interpretation only, but a substantial assurance of justice by reading section 100 of the Act as covering the whole basket of grievances of the candidates. Sri Rao contended that the court should not deny a relief to a party in an area of elections which are live breeds and a democracy and people's power. We agree. This dilemma does not arise in the wider view we take. Section 101D of the Act, Sri Rao's attack on the order impugns substance based on alleged non-compliance with the provisions of the Constitution, namely Article 324, but is neatly covered by the widely worded residual catch-all clause of Section 100. There was a remedy under Section 100. Here, my lord, we don't have any remedy. Then kindly could I come to paragraph 38. Article 324, which we have set out earlier, is a plenary provision vesting the whole responsibility for national and state elections. But again, this is in the background of the national and state election. Therefore, the necessary powers to discharge that function. It is true that Article 324 has to be read in the light of the constitutional scheme and the 50 Act and the 51 Act. Sri Rao is right to the extent that he insists that if competent legislation is enacted as visualized in Article 327, the Commission cannot shake itself free from the enacted provisions. After all, Matthew J. has observed Indira Gandhi, like I am not really traveling my lot with that word. Then, my lord, the important thing, paragraph comes. Our paragraph 41. Our conclusion on this limb of the contention is that the Article 324 is wide enough to supplement the powers under the Act as here, but subject to the several conditions on its exercise we have set out. Now we move on to close up the last submission bearing on the Commission's duty to function with the leading streams of natural justice. I am not troubling my lot with the natural justice theory, but the question is that the constitutional power is supreme. That is kindly come to paragraph 114. But I would rather tempted to read from paragraph 107. What is the scope and ambit of Article 324 of the Constitution? The Constitution of our country ushered in a democratic republic for the free people of India. The founders of the Constitution took solemn care to devote a special chapter to elections niched safely in part 15 of the Constitution. Originally, there was only 6 articles in this part, opening with Article 334. The penultimate article in the chapter, as it stands, is Article 329, which puts a ban on interference by courts electoral matters. We are not concerned is appeal with the newly added Article 329A, which is the last article to this chapter. Elections supply the vis-a-vis to democracy. It was therefore deliberately and advisedly thought to be a paramount importance that the high and independent office of the Election Commission should be created under the Constitution to be in complete charge of the entire electoral process, commencing with the issue of the notification by the President to the final declaration. We not concerned the other duties of the Election Commission in this appeal. Therefore, the decision of the Election Commission and his empowerment is constitutional, not bound by the statutes only. Kindly come to me, Lord. Paragraph 130. Being not altogether certain of all the facts and circumstances that may be made available in the appropriate forum, it may be a premature exercise by this court even to lay down guidelines wherein there is no hidebound formula of rules of natural justice to operate in all cases at all times when a decision has to be made. Justice and fair play have often to be harmonized with the exigencies of situation in the light of totality, accumulated totality of circumstances in a given case, having regard to the question of prejudice, not to the mere combatants in the electoral contest, but to the real and larger issue of completion of free and fair election with rigorous promptitude. The basic concern was, not even this constitutional bench, ensure free and fair election and don't disturb that. Now, next I invite my lord's attention to a judgment below reported in 2002, volume 5, Supreme Court cases. My lord will kindly turn to paragraph 25 onwards. This is 2002, volume 5, Supreme Court cases, page 294. Now, paragraph 22. For health of democracy,
(294)
paragraph 22. Or I am also tempted to read paragraph 21. Further, it is to be stated that one of the basic structures of our constitution is a republican and democratic form of government. The election to the House of People and the legislative assemblies on the basis of adult suffrage, that is to say, every person who is a citizen of India and not less than 18 years of age on such date as may be fixed in that by or under any law made by the appropriate legislature and is not otherwise disqualified under the Constitution, or any law on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice shall be entitled to be registered as a voter at any such election. Now, but then, that's being the foundation of democracy, kindly come to paragraph 22. Here below, the issue was whether the Election Commission can issue directions to declare the assets of the prospective candidates. Here the Supreme Court below says, for health of democracy and fair election, whether the disclosure of the assets of a candidate, her qualification and particulars regarding involvement in a criminal case are necessary for informing voters may be illiterate so that they can decide intelligently. But this was the issue on which the court went on. I am not wasting my lord's time. Then kindly come to paragraph 26. The aforesaid decision of the Constitution Bench unreservedly lays down that in democracy, the little man, voter, has overwhelming importance on the point, and the little large Indian should not be hijacked from the course of free and fair elections by subtle perversion of discretion of casting votes. In a continual participative operation of periodical election, the voter does a social audit of his candidate, and for such audit, he must be well informed about the past of his candidate. Further, Article 324 operates, but this is important, in areas left unoccupied by legislation, and the words superintendence, direction and control, as well as conduct of all elections are the broadest terms. The silence of statute has no exclusionary effect except where it flows from necessary implication. Therefore, in our view, it would be difficult to accept the contention raised by Mr. Salve, like a Solicitor General and so, that on behalf of the intervener, that if there is no provision in the Act or the rules, the High Court ought not to have issued such directions to the Election Commission. It is settled that power of the Commission is plenary in character, in exercise thereof. In statutory provisions or rules, it is known that every contingency could not be foreseen or anticipated with precision. Therefore, the Commission can cope with a situation where the field is unoccupied by issuing necessary orders. Now that here, on the last day, if somebody was prevented from my nomination, would the Commission then all look and say, I don't take cognizance of this? When the Supreme Court says the Commission's plenary power is not confined only by the statute. And this principle, my lord, has been followed by the Supreme Court in a subsequent decision when there was a reference by the President of India. Now, this is 2002, volume 8, Supreme Court cases, page 237.
দুটো হয়ে গেছে 2000 বার করে দাও এটা টাইম নেই আছে
Kindly turn to the paragraph 108. This part was delivered by Justice Paswat in the bench. Paragraph 108.
237.
Yes, my lord, 237, yes. At page 299. Lordship may turn to page 299.
নাম বলতে হবে, প্রধানটার নাম বলতে হবে। আমি নাম বল।
The democracy and free and fair election
Yes.
are inseparable twins. There's almost an inseparable umbilical cord joining them. The little man's ballot and not the bullet of those who want to capture power, starting with booth capturing, is the heartbeat of democracy. Path of the little man to the polling booth should be free and unhindered, and his freedom to elect a candidate of his choice is the foundation of free and fair election. Now, if the candidates are not allowed to file a nomination, how can he have the choice of his own preferred candidate? And if this is the principle, and on this principle, the Supreme Court says the power of the Election Commission is much higher than the statutory bindings.
বিকাশটা শেষ,
দাঁড়াও, ছটফট করছো কেন?
3:30 বাজে যে, ওই জন্য।
3.5 ঘন্টা দেবে নাকি?
একটু বলতে দাও। সাড়ে 3টে হয়ে গেলে কালকে বলবো, কি আছে?
আর ছুটি।
ও, তা শুক্রবার হবে, অসুবিধা কি?
order.
Kindly come to me, Lord. Paragraph 139. This is not presidential reference. That's why I am repeatedly, my Lord, pressing these paragraphs. In the interpretation of a constitutional document, words are but with the framework of concepts, and concepts may change more than words themselves. The significance of the change of the concepts themselves is vital, and the constitutional issues are not solved by mere appeal to the meaning of words without an acceptance of the line of their growth. Every day, my Lord, we are changing fast, my Lord, the nature, character, everything is changing. Therefore, we have to also, my Lord, go on interpreting dynamically. It is aptly said that the intention of the Constitution is rather to outline principles than to engrave details. Then, my Lord, the other judgments are taken care of, quoted. I am not troubling, my Lord, with that. Then kindly come to page 153. Sorry, paragraph 153. Free and fair election is the sine qua non of democracy. But this is very important expression, sine qua non of democracy. Therefore, democracy does not exist if the free and fair elections are there. The scheme of the Constitution makes it clear that two distinct constitutional authorities deal with election calling of session. It has been pointed out to us that as a matter of practice, the elections are completed within a period of 6 months from the date of dissolution, on completing the prescribed tenure or in premature dissolution, except when the inevitable reasons there is delay. The Election Commission is a high constitutional authority charged with the duty of ensuring free and fair elections and the purity of electoral process. To effectuate the constitutional objective and purpose, it is to draw upon all incidental and ancillary powers. Now, this, I stop here. The next portion is not relevant for our purpose. Therefore, the election has to be held with in such a fashion that it cannot prevent the election commissioner's right to deal with a particular situation. Now, kindly concluding paragraph 161. Paragraph 3, I just place it. As Article 174 does not deal with election, the question of election commissioner taking the aid, assistance, or cooperation of the center or the state government or to draw upon their resources to hold the election does not arise. On the contrary, for effective operation of Article 324, the election commissioner can do so to ensure holding of free and fair election. The question whether free and fair election is possible to be held or not has to be objectively assessed by the election commission by taking into consideration all relevant aspects. Effort should be to hold the election and not to defer holding of the election. Now, like, keeping all these things in mind, I would submit, my lord, when the court found there was a nomination, there is a power under the statute. The election commission, my lord, did not exercise its power. The writ court has authority under the law to direct that these nominations be accepted and let there be election, free and fair election. That being the foundation, I would appeal to your lordship not to interfere with the order which has been passed by the court. And
Sir,
this is no game to get yourself declared uncontested by not permitting me to file nomination.
sir,
What
kindly,
is that? If you have the
Mr.
Support.
Bachchan, in item numbers 2 to 6, you are appearing in all.
yes,
I'm
yes,
not sure.
yes,
আমি
yes.
স্বপ্ন আছি?
He is appearing.
2 to 6.
Yes.
All these cases, you would know better, Mr. Ahmed, factually. Is this the case of declaration of uncontested candidate?
Yes, yes.
All, 2
In
to
all.
6.
On 20th, our case is the scrutiny was held. Thereafter, there was no objection. Our name was appearing in the website up to 19th. In few cases, up to evening 20th. Thereafter, our name was disappearing. Between 17th to 20th, the date was fixed for withdrawal of nomination.
Did you implead the
I have-
successful candidate in your?
I was not aware of on that point of at that relevant point of time that in fact on the 21st when the matter was first taken up, election commission represented, the state represented, nobody's case was that our nomination was cancelled. And on the very first day, that is the first appeal, the appeals that those were filed previously, not today. In those appeals, those matters, single judge directed to accept our nomination to allow us to contest. Since there was no rejection, even there was nothing come forward before the single judge that our nomination was cancelled. Subsequently, after 2 days when other matters was filed, these were come. Sir, kindly cite 1996 CSCC 210.
This is
Nine-
almost a similar situation. Supreme Court declared election bad.
Sir,
1996 3 SCC
210.
210.
না আরেকটুখানি বাকি আছে।
Well, this is 1996 3 SCC page 210. Very short, Willard, order of the Supreme Court.
আরেকটা।
I just placed my paragraph. Though it is denied that the appellant had submitted the nomination papers for contest as Sarpanch, it would be difficult to believe the statement of the respondents that she had not filed the nomination papers. She had taken all necessary steps to file the nomination papers well within time. She had already been a sitting Sarpanch for over 15 years. Under those circumstances, one would legitimately expect that she had an intention to contest the election, and having secured necessary papers in normal course, she would have filed the nomination papers but for some supervening event. In her case, the seventh respondent had forcibly taken the nomination papers from her and torn them off. And since her husband was already under police custody at the relevant time, she was incapable of resisting the high-handed action. It is obvious that she was prevented from filing the nomination papers. Under those circumstances, she was constrained to approach the authorities. But when she did not get any tangible result, she had gone to the High Court and filed a writ petition, making all the allegations therein. Under these circumstances, we are of the considered view that the conduct of the election in these circumstances was not valid in law. We have a similar situation.
And only one thing, Mr. Bhattacharya has submitted before the single judge, but these orders, they have not annexed. That's why if I kindly take some, just one line, I'll show you, Mr. Bhattacharya has submitted in principle, just to hand over the copy of the orders and just one line from it. The situation which prompted these petitioners to approach the single judge, initially before the Justice Mantha, and thereafter Justice Sinha. Namlet, they were prevented, complaint was made, no assistance. Thereafter, kindly takes up page 2, last paragraph. Ancillary relief in aid of the main express prayer, this court deems it fit to direct the State Election Commission to exercise powers as vested on them under Section 46(2) of the West Bengal Panchayat Act and direct all concerned police station to render necessary assistance to those candidates who are not able to file nominations upon receipt of complaint in this regard on or behalf before the last date of filing nomination, that is tomorrow. And pursuant to this order, complaints are made to the authorities. Now, thereafter, again they were prevented. Or even on 15th, again we have approached the single judge. Single judge directed again post protection. Even thereafter, there was prevention, we were prevented, and then we reached there ultimately, thereafter filing of nomination. On the day of nomination, there was no objection. Nomination was accepted. Now, Mr. Bhattacharya has already placed, only one thing he has missed. The scope of scrutiny vis-a-vis scope of protection petition, he has argued. Section 49(7) that he has not placed. এটা place করা দরকার আছে কিনা? Sir, should I place this provision or not? Unmute.
At the time of the court.
Sir?
দরকার নেই কোনোটা।
Then I'm not placing. And entire thing was videographed. Entire scrutiny was videographed, and there was no objection in terms of the direction of the Honorable Division Bench.
What more?
I am the affected party only. I am the affected party. These are all a lot of academic discussion going on.
Any other point?
Yes. To reply. First, my lord, I will conclude.
When will you conclude?
Within 3:30, and rest is my lord.
The bench at 3:25. Is a different bench.
Abandon that bench.
No matter is important enough to abandon a bench, Mr. Basu.
5 minutes, my lord thought that it will be up to 4:30. That's why my lord has kept that bench. Well, kindly see first the Mohinder Singh Gill's case. Let me start with that. Kindly come to paragraph 92.
Only answer, no, just tell us one thing.
Why?
How will this order interfere with the election in the sense will have an adverse effect or have the tend to stop the election? How?
Because today I have been declared elected.
That's a different point. That's a different point. I'm on the point of whether the only remedy is to file an election petition after waiting for the election to be over, even if my nomination has been wrongfully
illegally
rejected.
Or accepted illegally. In both cases, election petition.
Either case. I am not trying to stop the election. As they are arguing, they are not trying to stop the election. It's in aid of a fairer,
Right.
more proper election.
Now the point today, position of law, which came into force, that my candidature has been accepted, I have been declared elected. Today, my lord, may I ask this question to myself? Who can alter it?
Now, Mr. Basu, if that is, as I said, that's a
Who
different
can alter
point.
it?
That's a different point. Then, was that disclosed before the learned single judge that there is already
Yes.
declaration of a successful candidate?
Kindly see the order.
No, it was not. It was not before.
In
the
this
learned judge.
petition, this is not this, where I have appeared. Eta ami appear করেছিলাম কি না? Eta no. Here, my lord, we have not been made parties. The other matters.
That's right. So the learned judge was not told that somebody has been declared to be a successful candidate uncontested.
But fact remains that the fact is that
Then we'll send it back.
fact is that because today what happened, my lord, in my matter, the candidate who is now campaigning because of the order of the justice single judge.
Mr. Basu, then we'll add you as a party and send it back.
Yes.
Let the learned judge decide in
Decide
your
it.
presence. Rightly or wrongly, well, we'll hear in reply, we'll hear
No, probably my lord is hearing 1 to 6
2 to 6.
to 6. Mine is 7.
Correct.
7 is something else. My lord, kindly come to 7.
Thou 7 thou. Ye chuk.
এটা কোথায় গেল? অর্ডারটা কোথায় আছে? না, চিফ জাস্টিস অর্ডারটা না, ইমপ্রিন্ট অর্ডারটা। মেমোটা কোথায়? Yes.
Identical order, Mr. Basu.
My lord,
Identical order.
no, kindly come to the last portion of the order. In view of the above, the State Election Commissioner, though the Panchayat Electing Officer, is directed to permit the petitioner to contest the election.
Identical order in 2 to 6,
Oh,
identical.
Then, my lord, I am not there. So in this petition, my right of being elected sought to be taken away.
Understood. We have understood.
But thereafter, I have another matter which has a leave of it obtained yesterday, and probably tomorrow, Friday, it will be appearing in a lordship list. That in spite of knowledge, it has been done. And if my lord is
Milord, perhaps a separately submissions need not be made before the learned single judge, Milord, because it is the law says the moment there is nobody to contest, there will be a form declaring
No,
that
no,
this
no.
is an uncontested seat.
no. My lord, want to know whether that has been disclosed to the honorable single judge.
And Milord,
It
Was
was
it
not.
brought to the notice of the learned single judge that a person has been declared to be success? Sorry, my sister is waiting on the corridors. For orders, day after tomorrow.
Malad, kindly keep our matter at least to be mentioned, item number 50, because unless I gave a particular,
But you know,
আমার তো কোনো মাঝি লটের কাজ।
certainly
মাই লটের কাজ। আমাদের কাজ কি?
এইগুলো সব যা
এবার judgment
জেরক্স ফেরক্স ইচ্ছু করো, শুধু 2 নম্বরটা কাটো,
সেটা
সবই থাকবে। There will be separate orders, better না?
in those matters,
number-
separate, no separate, no.
2 নম্বরটা অর্ডার করো 2 নম্বরটা।
এটা আমার কাছে থাকে একটা কপি।
Heard Mr. Kishore Dattu, learned senior advocate for the appellant, Mr. Kollan Bandyopadhyay for the state, Mr. Bikash Ranjan Bhattacharya for the respondent oblique writ petitioner. সব learned senior advocate করে দেবে পরপর। Stop. Paragraph. The hearing is not concluded. Stop. Paragraph. List the matter once again on Purshudin, marked for orders, under the heading for orders.
কোন বইটা কখন হচ্ছে?
2 p.m. 2 p.m.
Right, and 2 p.m.
2 p.m.
Not possible in the morning.
Not possible, Mr. Vasu.
There is a resolution, my lord, probably my lord registered to my lord's
Says what?
knowledge.
a resolution.
There is
To do what?
any order in absence of the parties. As
Why should you be absent?
But we are thinking that this might give Milord some chance to hear it earlier.
if possible, my lord,